CR 0145, you're charged with the third-degree felony offense of assault on a public servant from October 30th of 2024. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you actually did what they've charged you with? Speak up, please. And then in cause number 25 DCCR 0146, you're also charged with a third-degree felony offense of assault on a public servant from October 30th of 2024. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? Speak up, please. And are you pleading guilty because you did what they charged you with? In each of these cases, I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Ms. Holmes? Do you fully understand them? And do you understand, if I follow the agreement that you made with the district attorney, that you will be waiving or giving up any right to appeal? So if I follow the agreement, you can't change your mind later. Do you understand?
Yes, ma'am.
And it looks like the agreement that you've reached in each of your cases is for a 6-year deferred probation. There would be a $300 fine, and you would be required to follow all of the rules and conditions of probation. Plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law. State tenders number 1 in each case.
No objection.
It's admitted in each case. Is there any evidence that Ms. Sparks is not competent?
No, Your Honor.
All right, ma'am, I'm going to find that you entered your pleas of guilty in each case freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence in each case to find you guilty. However, I'm going to reset your cases for sentencing so that the probation department can do a pre-sentence report. That'll give me more information about you and your cases, and then we will come back at a later date for sentencing. Mr. Nichols, what is the state's position on bond?
Judge, I'm a little concerned about a PSI bond because of the way these cases occurred. There might be an issue that I do anticipate she at the very least being placed on mental health caseload. I don't think it's a competency issue. I've discussed with Ms. Holmes, but I don't know if the court's going to decide that either an ISF or a safety program is in the best interest here.
Okay.
The facts in this case involve threats or concern, and there was one jail incident in the last week that gave me a little concern as well.
Okay.
Yes, Your Honor. So Ms. Sparks and I have spoken with her mother. Her mother is here. On this particular incident, there was a episode. She had a mental episode where she was not on medication at that time. She is compliant on medication now.
Okay.
And we are asking, her mother is taking care of her child. Her child was attending that school that she went to. And so I do feel that if she stays on her medication and stays.
In today's courtroom session, everything changed in seconds. One defendant failed to appear, another was lost between counties, and a third stood speechless as the judge issued a $10,000 warrant on the spot. A simple scheduling hearing spiraled into unexpected drama, pleas entered, warnings delivered, and patience pushed to the limit. This is what really happens when the judge has finally had enough.
And so we were asking if the court would consider a PSI bond.
I guess the concern is without the probation order, where has she been to Spinal Top before? Have you gone through Spinal Top before? You are a Spinal Top patient?
She's diagnosed bipolar and major depressive disorder.
Okay. So what I'm going to do, Ms. Sparks, just kind of based on also time of the year, I'm going to reduce the bond, but I'm going to have some very specific conditions on that bond, and you're going to have to follow those conditions Exactly. If you don't, because you're going to have to give Ms. Holmes proof that you're doing some things that I'm going to order you to do. And if you're not doing those things, then I'll issue a warrant for your arrest. We'll get you back in custody until that pre-sentence report's done, and then we know what everything is that you could potentially need. Was there also any type of, or is there any kind of drug issue, or is it primarily mental
It
health?
was just mental.
Okay, so Ms. Sparks, I'm going to reduce your bond in each of your cases to $2,500. If you make those bonds, the conditions of the bonds are that you immediately have an appointment, make an appointment with Spindletop, that you give proof of when that appointment is to Ms. Holmes. So I'm saying the day you get out, you make the phone call, you set an appointment, and Ms. Holmes needs to know when that appointment is. You don't wait a week to set the appointment or 2 weeks or anything like that. You set it the day you get out of jail if you make the bonds. Does that make sense? In addition, I am ordering that you remain on your medication. So now it's not just whether you want to or you feel like you need to, it's a court order. And if you don't do it, you're back in custody. Do you understand? So is her mother okay with her living with her? Where's mom? Thank you, ma'am. And thank you for being here. So I'm going to order that you remain living at your mother's house. You can't go spend the night anywhere else. You can't go anywhere else. You stay there. You go to Spindletop. You get yourself back on track so you can be fine and do this probation and not have any issues. Does that make sense? You are not to go to any of the schools wherever your child or children are going to school. You are not allowed to go there, period. Do you understand? Okay. That's going to, not until I order otherwise. So for now, you cannot go to any school that they are attending. Okay? If somebody needs to pick up and drop off, that's going to be her or someone else. If there's a school program between now and when you come back, I don't care. You don't get to go. Do you understand how serious I am about that? Okay. Any other conditions that you feel
I
like?
think that will cover it, Your Honor.
Okay. All right. We'll see you back at sentencing. You can go back with the bailiff. Okay, I'm writing it all on my docket,
Here, I was gonna say,
so I'll write it again.
you don't have to, I
Here, just keep it to the side and I'll do it. Remind me. But I did write it all down.
can. Okay, thanks.
I read the paperwork on my judge.
Okay, thank you. Mr. Kimler, what is the announcement on Jeremiah Branch? Okay, I'll hold it and take care of those when they're ready. Mr. Lewis, I was holding Russell Bean.
Just that one, I've gone next door to check, see what Mr. Cole got.
Oh, okay.
But he hasn't, he hasn't.
We're
got it
waiting
yet.
on that. I need to make that note. Okay. What about Denzel Spikes?
Yeah, that was a plea.
Okay, I'll take care of that when it comes through. Let's see, on Cecilia Delaney, did y'all get her? Yes. Let's take care of Miss Delaney, Mr. Parker.
Forgot about that one.
And this is one where they say outpatient, but I don't have,
Do we think she needs to go for longer than the 120 days?
well, it'll be a civil commitment today for a year. So that's why we had to bring her back, because that was just for the 120. And so now I can do the civil commitment for the 1 year. And even though it's recommending outpatient, I'll make it inpatient so that, because we don't have an outpatient.
All the way down number 78 on the list to get done.
Mm-hmm.
For you?
I don't know. I'll go for a while. Yeah, why not? Is it a state jail felony or is it a third? We also need to watch out for
statute.
Okay,
I don't keep on.
yeah.
Because it isn't, because it isn't public danger.
Right.
Thought we just did some September.
Just when we were trying to get a lawyer.
Yeah. Oh, that's right.
No, why they have this giant, it's too big.
Sharon would have done it first try.
All right, this is cause number 24, DCCR 1386, and are you Cecilia Delaney? And Ms. Delaney is in court, was previously found not competent to stand trial, was transferred to the John Dunn Behavioral Science Center for competency restoration for a period of not to exceed 120 days. I have received the report from them, and we'll take judicial notice of the court's file, including that report. Included in that is the trial competency evaluation report, which was prepared by Dr. Mary Ann Robinson. The opinion in that report is that Ms. Delaney is still not competent to stand trial, and that further treatment would be required for competency restoration. See, in addition, there is a forensic psychiatry report that was prepared and by a Dr. Selleck, S-E-L-E-K. Again, the finding it with him is that she is not competent to stand trial. Additionally, we have a physician certificate of medical examination for mental illness from Dr. Selleck. The finding in that is that Ms. Delaney does not meet the criteria for inpatient commitment, but meets all of the criteria for an outpatient commitment, with the specific findings that the nature of the mental illness is severe and persistent. As a result of it, if not treated, that she would experience deterioration and the ability to function independently.
What began chaos when defendants went missing, warrants were triggered, and the judge demanded answers. From bail violations to no contest pleas, each case unfolded with rising tension. And when a defendant admitted misconduct, the judge laid down strict orders with zero hesitation. This is the side of the justice system the public never sees.
And in addition, we have a second physician certificate of medical examination for mental illness from a Dr. Lee. The finding is the same in that Ms. Delaney meets the requirement for outpatient commitment based on the nature of her mental illness being severe and persistent, and that if not treated will experience deterioration and the ability to function independently. That's it. It's another one? Okay, so that being said, well, is there any other evidence with regard to competency?
No, Your Honor.
So obviously, you guys both know we do not have an outpatient treatment facility in Jefferson County.
Right.
We don't have a jail competency restoration or outpatient competency restoration. So that being said, I have no choice at this point but to find that Ms. Delaney is still not competent to stand trial, and find that commitment inpatient would be required because we do not have outpatient commitment facility, because the nature of her mental illness is severe and persistent, and that if not treated, she would not be able to function independently and live safely in the community without the court-ordered treatment services. And so I am going to order a civil commitment for a period of not to exceed 1 year for competency restoration at the appropriate facility. If there is restoration prior to that, they'll let us know and we'll get Ms. Delaney back. Otherwise, we will wait for their report and have a hearing at that time. Ms. Delaney can go back.
The courtroom quiets as Maya Sparks faces 2 felony charges that can't be undone. Deferred probation promises freedom, but one mistake could erase everything. The tension peaks when the judge pauses, about to decide how much risk is too much. Maya pleads guilty, accepts probation, and listens as prosecutors raise serious concerns. Mental health, school threats, and jail incidents push the court to a breaking point. Then the judge offers help, with conditions so strict they could change everything. In a quiet courtroom, Maya Sparks stands before the judge as routine questions hide the weight of 2 felony charges. The formal reading of assault on a public servant forces her to answer clearly, committing herself to guilty pleas that cannot be taken back. 6 years of deferred probation sounds merciful, but everyone in the room understands how fragile that deal truly is. The prosecutor subtly raises alarms, mentioning school staff and a recent jail incident, signaling risk without shouting it aloud. Defense counsel points to mental illness, missed medication, and a family struggling to keep balance. The judge listens, measuring safety against compassion, before choosing a careful compromise. Bond is reduced, yet replaced with strict conditions that leave no room for excuses. Maya must live with her mother, remain medicated, avoid schools entirely, and immediately engage mental health treatment. One missed step means arrest. Hope exists, but it is tightly controlled, bound by invisible restraints that follow her even outside the jail walls. As the docket continues, the courtroom shifts to another reality. Cecilia Delaney's case exposes the limits of the system itself. Multiple psychiatric evaluations agree she is not competent, and outpatient care is impossible in the county. With no alternatives, the judge orders inpatient civil commitment, prioritizing treatment.